So this morning, in introducing the day's events, David described the program as involving philosophy, politics, economics, and law, and all from a normative perspective. I'm going to do 4 out of 5, which I think is not bad. I'm going to do a little philosophy, a little politics, a smidgen of economics, some law, but nothing normative. So you can decide whether 4 out of 5 is enough or not. But I'm delighted to be here and delighted to have a chance to talk about this. So the title of the talk is The Political Risks, if any, of Breaking the Law. So for most people, most of the time, breaking the law is risky business. When people violate the law, they face the possibility of prison, fines, injunctions, damages, and any number of other ordinarily unpleasant consequences. But although law breaking is typically fraught with risk, it is not so clear that that generalization applies to public officials. The laws that constrain public officials, especially but not only the laws that exist as part of the Constitution, are frequently unsupported by the tangible penalties of the legal system. And this is especially so for public officials in the highest reaches of government. There are many constitutional constraints, for example, on permissible legislation, but no formal penalty threatens the legislator who votes for an unconstitutional law. Similarly, few official legal sanctions are available against a state executive official who violates the Constitution behind the shield of qualified immunity from a civil rights action, or against the judge who issues an unconstitutional ruling, or a prosecutor who acts unconstitutionally in prosecuting a case, or a federal official who, for reasons of immunity or otherwise, is beyond the reach of personal liability. That formal legal penalties are rarely available to punish or deter a wide range of official illegality need not produce the conclusion that official law breaking is beyond sanction. Appointed officials can, after all, be fired, disciplined, or denied promotion. Elected officials can be voted out of office. Moreover, many officials will have concerns about their place in history or their station in post-political life, and could accordingly be worried about the effect of illegality on their short-term or long-term reputations. But do any of these less official sanctions for lawbreaking actually exist? And how often and against whom and under what circumstances are they applied? My goal here is to explore just these questions. I want to inquire into whether violating the law is, for public officials, at least in the United States, and especially for those public officials who are most prominent and at the loftiest levels of government, a politically risky action. And if so, what those risks are, and for whom, and under what conditions they do or do not exist. I'll begin with an attempt to clarify the question of obeying or disobeying the law, drawing on a rich and long-standing philosophical literature. I'll then examine the issue of legal compliance and the political sanctions for non-compliance in light of a number of recent issues, especially an example involving American military action in Libya and its potential violation of the War Powers Resolution. More briefly, I'll survey a bunch of other recent and not so recent examples of official disregard for the law and the consequences, if any, flowing from that disregard. And finally, I'll offer an informal framework, not a model, not even a fully worked out utility function, although an approach that might enable others to construct one or the other model, or designed to embody larger lessons that might be drawn from these examples. To preview my conclusion, I'm going to argue that violation of the law seems to have a complex political effect, such that, formal sanctions aside, the fact of law violation appears to play only a small role, at most, in constraining a certain class of relatively high and electorally responsive officials from engaging in those actions that are or turn out to be acceptable on policy and political grounds. But that law violation seems to increase the political penalty for those official actions that are or turn out to be unacceptable on policy or political grounds. Because officials making policy decisions cannot ordinarily predict ex ante with anything close to certainty whether the actions produced by those decisions will turn out to be acceptable or unacceptable on policy and political grounds, rational officials will, or at least should, engage in a complex calculation in which the increased political penalty for unpopular actions that are also illegal will cause them to require a higher standard of justification or confidence before taking illegal actions that may turn out to be unwise or unpopular than before taking legal actions that may also turn out ex post, that before taking legal actions that may also turn out ex post to be unwise or unpopular. So, what is it for an official to obey the law? Indeed, what is it for anyone to obey the law? For present purposes, I draw on a rich and extensive philosophical and jurisprudential literature focused on precisely this question, and indeed a literature to which people in the audience and part of this event have been significant contributors. So when people obey the law, they take the very existence of the law, the very fact of a legal requirement, as a reason for conforming their actions to what the law directs. They comply with a law when they treat a law's mere existence as a reason for action. This seems simple enough, but in many respects it's less simple than the brief summary suggests. In the first place, it's important to distinguish between actions that are taken because of the law and actions taken for other reasons that simply happen to be consistent with the law. Assaulting those of my colleagues who speak interminably at faculty meetings violates the law, but the law plays no part in keeping me from doing just that. The reason I do not succumb to the temptation to secure their brevity with a baseball bat is simply that it would be wrong to do so, where wrongness is entirely a pre-legal or extra-legal matter. Engaging in such an action would be both morally wrong, and I should add, prudentially dangerous for me, and so I do not do it. But the law plays no role at all in my moral or prudential calculations, and no role in my final decision about what to do. Similarly, my unwillingness to engage in murder, rape, theft, insider trading, cannibalism, and a host of other activities is, depending on the activity, a complex algorithm of moral views and personal preferences, but the law is not even the smallest component, at least for the examples I've mentioned, of that algorithm. It would be odd to say that I obey the law against murder or follow the laws prohibiting cannibalism, although it is certainly the case that my behavior in no way violates those laws. The situation is different, of course, when violation of law is likely to produce a sanction. Although a change in the laws regarding assault and cannibalism would have no effect on my behavior, this is not the case, at least for me, and I suspect most others, with respect to a considerable number of other laws. When the speed limit rises, so too does the speed at which I ordinarily drive. But my obedience to the speed limit is, for me and vast numbers of other drivers, largely a function of fear of sanctions. And that is why I drive at no greater than 74 miles an hour when the speed limit is 65, even though I am often convinced that I can drive with perfect safety under those conditions at 78. Thus, when the speed limit rises to 70, as it relatively recently did on Interstate 64 between Charlottesville and Richmond, I tend to drive at 77 to 79, even though I was previously driving at 74. I believed that 65 was too low when that was the speed limit in force, but it influenced my behavior solely because of the sanctions that attach to violations. And although this may be a trivial example, there is little doubt that for vast numbers of people on countless occasions, it is the fear of fines, imprisonment, civil liability, and other sanctions that's the dominant factor in producing genuine obedience to law, in causing behavior that is, as it is, precisely because of the law, in contrast to behavior that's the product of other and law-independent motivations, but which just happen to be consistent with the law. The threat of sanctions thus often produces genuine obedience. For much of law, much of the time, it is the sanction attached to violation rather than the simple fact of the law being the law that is doing the work. That is, we must, following HLA Hart, distinguish treating the very fact that something is the law as a reason for action or decision from the fact of the sanction for disobedience as being a reason for action or decision. Yet although we should be attentive to the distinction, we're likely still to discover that in most cases, for most people, the presence of sanctions makes sanction-produced obedience and obligation-produced obedience identical as a practical matter. Some people may indeed pay taxes or obey the speed limit simply because they wish to comply with the law. But so long as non-compliance is risky in a sanction-based, tangible way, then the widespread conjunction of the two, the widespread conjunction of a felt obligation to obey the law because it is the law and the sanctions makes it difficult to separate the two, and thus difficult to assess the prevalence of those who wish to comply, even when they think it is not in their interest to do so, and even when they think the requirement is mistaken. When we turn from ordinary individuals to officials, however, the issue becomes crisper. And that is because, as I mentioned earlier, there are an appreciable number of legal constraints on the actions and decisions of public officials that are not supported by the threat of formal sanctions. A member of Congress who votes to allow a prosecution for treason with only one witness in plain violation of Article 3 of the Constitution would not be liable for legal punishment on account of such an act, nor would the president who signed such a bill. More realistically, prosecutors who bring unconstitutional prosecutions are immunized from liability for such actions, and the same applies to judges and various other officials. At times this immunity is absolute, at times it's qualified, but the fact that the officials with even qualified immunity are rarely subject to sanctions, especially if they are high-level public officials, suggests that in practice the protections of even qualified immunity are substantial. So for an appreciable number of officials and official acts, there is no genuine chance of legal formal liability, and the risk of legal sanctions can accordingly be separated from the sanction-independent commands of the law. And if we combine the sanction-free environment in which most official actions take place with the analysis above, with the distinction between actions taken because of the law and actions taken for other reasons that happen to be consistent with the law, we can then isolate the question. As so isolated, the question is about the frequency with which, the possibility of legal sanctions apart, officials take actions other than the ones they would have taken on law-independent grounds simply because of the law. In other words, to what extent do public officials, especially sanction-immune high public officials, genuinely internalize the law as law? One objection to framing the question in this way is that it assumes that legal obligations are bimodal, being either absolute or non-existent. Such a way of understanding the issue is somewhere between misleading and plainly false. That the fact of law as law provides or might provide a reason for action is not necessarily the same as it providing a conclusive reason for action. Consequently, the reasons for action that law may provide might be considered prima facie, in the philosophical and not the legal sense of that term, prima facie, and could be outweighed in this or that case by even stronger reasons for taking an action inconsistent with the law. Martin Luther King might well have believed, for example, that he had a genuine obligation to obey the law, but he appeared to believe as well that such an obligation was defeasible, and that in some circumstances, as he saw the moral urgency of taking an action inconsistent with the law provided an even stronger reason, and thus a stronger obligation going in the opposite direction from his perceived obligation to obey the law. So from any single action inconsistent with the law, we cannot infer that the actor felt no reason to obey the law, or perceived herself as having had no reason to obey the law. But when we're considering an aggregate group of actions over time, the inferential process is different. If we were to discover that some agent or group of agents had, over a large number of decisions or actions, repeatedly taken actions consistent with their law-independent preferences, but in contradiction to the law, and had rarely or never taken actions consistent with the law that were inconsistent with their law-independent preferences, we would have at least a somewhat sounder basis for concluding that, for those agents, the obligation to obey the law provided at best a weak reason for action. If the obligation to obey the law provides for some group non-conclusive reasons for action, we ought to expect over a large enough run of instances to see at least some instances in which the non-conclusive reason actually determined the outcome. If we discover none or few, there are good grounds for at least suspecting that this reason simply did not function as a reason at all for that agent. That, then, as clarified, is the question I am addressing. To what extent do officials, especially in domains in which the possibility of a legal sanction is formally or practically non-existent, follow the law, or take the commands of the law as reasons for action, just because it is the law? It is a question, I think, of pervasive practical importance, especially in public law, in large part because so many prominent public law actors are not subject to formal legal sanctions, and partly because the rhetoric of obedience to law plays such a large role in public, political, and journalistic discourse. If in fact genuine obedience to law as law is the exception rather than the rule, and if genuine obedience is rarely rewarded and sometimes condemned, then the effects on how law ought to be designed and on how public discourse ought to be conducted may be profound. So as I just noted, one thing that makes the topic of official obedience to law both interesting and potentially important is the possibility of a disjunction between official practice and official rhetoric. Although few officials would claim to reject the law as a reason for decision, and although many of them actively trumpet obedience to law as an important value, their actions may belie their rhetoric. That is, officials may talk about the value of obedience to law when the law-conforming actions to which they are referring are ones they would have chosen on law-independent grounds. But when the law requires them to take actions inconsistent with their law-independent preferences, they may sometimes, often, or almost always, when no legal sanctions are in the offing, choose to go with their law-independent preferences rather than with the law. So a revealing contrast is provided by the distinction between the reactions to the invasion of Iraq and to the bombing of Kosovo, both of which were roughly equivalently illegal under international law. Now, international law is far less salient in American political debate and public opinion than domestic law, but it is nevertheless worth noting that those who objected that Iraq was a violation of international law had rarely, if ever, made the same claim with respect to Kosovo. To the extent that this example is representative, and to the extent that it is representative over a large enough run of decisions, the rhetoric of obedience to law may be undercut by the empirical fact of frequent disobedience. Moreover, if we assume that officials behaving in such a way are often accurately perceiving and responding to the preferences of their constituencies, the widespread presence of preferring first-order substance to the second-order constraints of the law, if in fact such preference exists, may tell us a great deal about the extent to which, if at all, law as law is actually a value the society has internalized. So consider as an example the legality of the recent American involvement in Libya. Factually, the issue arises from the situation in which the Obama administration directed strikes against Libyan air defenses, some by aircraft and some by remotely operated drones, in conjunction with NATO, but without prior consultation with Congress and without approval by Congress, either in advance or to this day. In defending its refusal to consult or secure congressional approval, the administration relied in part on now routine presidential claims to have independent constitutional authority under the explicit commander-in-chief and executive powers and the implicit war-making and national defense and foreign policy and emergency powers to engage in such actions. But in seeking to explain its disregard for the clear mandates of the War Powers Resolution, the administration also claimed, in the face of a clear Office of Legal Counsel opinion to the contrary, that the military actions in Libya did not constitute hostilities, as that term is used in the War Powers Resolution, because no American ground troops were placed in Libya, and also because the likelihood of American casualties was essentially non-existent. The claim that the War Powers Resolution is in some or all dimensions an unconstitutional infringement on the president's independent powers is seriously debatable. And in fact, this is the position that has been taken in one form or another by every president, regardless of party, since the resolution was first enacted in 1973. But the claim that the resolution did not even apply to this situation because there were no hostilities was widely mocked as legally implausible, especially in the several days after the administration's written statement to that effect was issued and after it was defended before the Senate Foreign Relations Committee by Harold Koh, legal advisor to the State Department. For purposes of this paper, it seems more than plausible to treat the defense of the actions over and against Libyan forces as so weak to permit the claim that the actions simply violated the law in a straightforward way. Yet although the actions violated the law, they were plainly preferred by the administration on policy and presumably political grounds. And as events have ensued, it is clear that the administration's policy and political positions have been borne out. The air attacks were successful, the forces of a very bad person were defeated, the regime seems to have changed, at least for now, for the better, and there were no American casualties. The entire scenario, therefore, seems a good example of one in which, faced with a choice between the law-independent policy preferences and the clear constraints of the law, the administration chose the former. What makes the example interesting, however, is the fact that the policy and political success, even in the face of relatively plain illegality, has produced virtually no negative political consequences. Public and press attention to the illegality has disappeared, and the political evaluation of the action has been largely positive. As the events have played out, the illegality has played essentially no role in the larger politics of the situation. To put it differently, not only has the illegality produced no formal legal sanctions, as it could not, short of impeachment, but it also seems to have produced virtually no political or reputational sanctions for the administration. As of today, it remains logically possible that the administration's violation of the law will be a campaign issue in 2012, but the likelihood of such an eventuality seems vanishingly small. There are many other examples of illegal policy actions or positions that seemingly have produced no or few negative political consequences. One is the decision by the mayors of San Francisco and of New Paltz, New York, some years ago to marry same-sex couples in violation of the then applicable state law. With sympathies in both of these states in the direction of legalizing same-sex marriage, the illegality was taken then and is taken now as being somewhere between inconsequential and courageous. On the same issue, when Governor Patrick of Massachusetts explicitly urged members of the legislature to disregard a decision by the Massachusetts Supreme Judicial Court mandating that they vote on a referendum proposal to amend the state constitution to prohibit same-sex marriage, his actions have produced no negative political fallout. In numerous other instances, from New Orleans Mayor Ray Nagin's public call for immediate federal military assistance in the wake of Hurricane Katrina. And he said, I don't have the quote right in front of me, but very close to, "I don't care about the law, get those troops here now." To Mayor, now Senator Ray Menendez's support for Americans who would have illegally launched military actions against the Cuban regime, to the violation of New York's Taylor Law by leaders of the Transit Workers Union and other public employees union. The fact of illegality in the face of popular policy initiatives or positions tends to yield, or seems in these cases to have yielded few or no negative political or reputational consequences. Less saliently, the frequent willingness of Congress to ignore the law of lawmaking may be another example of the same phenomenon. Here, as elsewhere, the compared to what question is crucial. Thus, my claim is not that these examples suggest that law as law never matters. My claim is the more modest one, emphatically subject to much more systematic research, that the law appears to matter to high-level public officials and in public political life somewhat to more than somewhat less than the rhetoric of those officials would suggest, less than the general public rhetoric of obedience to law would suggest, and possibly less than it has in the past and less than it does in other countries. These claims are, in theory, testable, and my examples are selected not because they are necessarily representative, but because they provide, at least for me, some basis for tentatively accepting the hypothesis that disregard for the law, as I have defined it, and for the class of officials on whom I am focusing is widespread. Indeed, my methodological disclaimer is that I do not, as I said, I do not claim that the examples are necessarily representative. They have been chosen to suggest a testable hypothesis, a hypothesis that a more systematic examination of the political consequences of official illegality could then evaluate. The divergence between the examples and much of popular and political rule of law rhetoric indicates to me that there is a phenomenon worth investigating and assessing. But it could turn out that the examples are more atypical than representative, and that obedience to law, even without sanctions and even in the face of opposing policy and political preferences, is far more the norm. Yet because it is almost inconceivable to imagine a genuinely systematic empirical investigation of the phenomenon using real-world practices, the number of instances being almost infinite, and the number of variables being huge, it's possible that carefully designed experiments might not be the best way of examining the issue, even though it would be nice to try to do so. Nevertheless, I at least want to signal the methodological difficulties and emphasize that what I'm offering is a potentially testable hypothesis. But even if the foregoing examples are shown to be representative, it would be a mistake to conclude that violation of the law does not matter in public and political evaluation. And it would be a mistake because the fact of law violation does seem to matter when the illegal official actions are less successful or turn out to garner less political support. Consider, for example, the various actions of the George W. Bush administration regarding Iraq and terrorism. Many of these actions, certainly including the torture by waterboarding of various proved and suspected al-Qaeda operatives and the surveillance without warrant of American citizens, explicitly violated clear law. For example, the Foreign Intelligence Surveillance Act. These illegalities attracted substantial political and public condemnation, and such condemnation persists this day. But what also persists is a strong public and political sense that the so-called war on terrorism remains a work in progress, with terrorism still a substantial fear among many Americans, and an even stronger public and political sense that the invasion of Iraq produced few benefits, and certainly not the quick resolution followed by cheering Iraqis that the Bush administration had initially envisaged. There are, in the longer version of this, some number of other examples. Iraq-Contra may be one, and a few others. Again, these examples may not be representative. And a larger number of examples, especially examples designed to test various counterfactuals, would be necessary to determine the representativeness of the examples. But insofar as these examples as well are representative, they might assist in establishing the proposition that illegality has turned out to be important when the law-independent policy goals and policy accomplishments have turned out to be unpopular. The foregoing examples suggest the following hypothesis. When illegal policies are successful on policy and political grounds, and when formal sanctions are unavailable, the fact of illegality will be relatively inconsequential. But when illegal policies are unsuccessful on policy and political grounds, the fact of illegality will increase what would otherwise have been the political and reputational penalty for officials responsible for those policies. Again, the hypothesis should be understood as a statistical claim and not an inexorable phenomenon. That is, the hypothesis is that policy and political cess will likely decrease substantially the political and reputational costs of illegality, and that illegality will likely increase the political and reputational costs of policy failures. In the context of this paper, I don't want to test or investigate the hypothesis further, although I do believe that framing it as I have will assist in the endeavor of actually doing systematic examination. So I want to turn to examining the implications of the factual hypothesis if it is in fact true. And as I said, I want to do so by way of a very informal and decidedly non-mathematical model. Maybe I should call it a suggestion rather than a model. So for present purposes, I want to take the point of view of an official contemplating some official act. A president ordering a military strike, a member of Congress introducing or voting for a law, an executive department official considering an enforcement action, a political figure of any kind writing a speech expressing approval or disapproval of someone else's action. And I want to assume that the official believes that the action is good policy and believes as well that it is illegal, and finally has no reason to fear a formal sanction on account of that illegality. With these assumptions in hand, we need to recognize that the official taking this action is doing so under conditions of uncertainty regarding the success of the policy and its political reception. So assume for the moment a high correlation between policy success and law-independent political evaluation. assume, as with Libya, that policy successes will produce the law aside favorable political evaluation, and that, as with Iraq, policy failures or disappointments will produce the law aside unfavorable political evaluation and unfavorable political consequences. But ex ante, the official cannot be certain that the action she hopes will succeed will in fact succeed. Under such circumstances, the rational official, operating under conditions of uncertainty, will have reason to fear the unsuccessful and illegal policy more than the unsuccessful, albeit legal, policy. Or, to put it differently, a successful illegal policy will yield a higher payoff than an unsuccessful legal policy, which will in turn yield a higher payoff than an unsuccessful illegal policy. And thus, the rational official will require either more confidence of success in the case of the illegal policy than in the case of the legal policy, or will require greater payoff in the event of success in the case of the illegal policy than in the case of the legal policy. This is plainly a matter of expected value, in the sense that the official will be assessing both the payoff of some policy if successful and the probability of the policy being successful. Consequently, the rational official will need a higher expected policy value in the case of illegality than of legality, and importantly, this is so even if illegality turns out to be of no negative consequence, as with Libya, should the policy succeed. The previous discussion allowed for uncertainty about policy consequences, but did not take account of uncertainty about legality. In reality, however, the rational official will take into account her own uncertainty about intrinsic illegality, as well as about the public and political perception of illegality. In some cases, this uncertainty will be inconsequential. Someone asking the question ex ante whether the Iran-Contra scheme violated the Boland Amendment could not have been in any serious doubt about the answer to that question. With the question about whether airstrikes count as hostilities or whether waterboarding count as torture, the question may be imbued with slightly, although in my view only slightly, more uncertainty. And this uncertainty, seen from the vantage point of the legally informed or informed by legal counsel official, will have two components. One is the sense in which there is uncertainty about illegality itself. The other is the sense in which there may be uncertainty about the public and political perception of legality or illegality. And this additional uncertainty about legality complicates the model, but does not detract from the basic point. Even with the new uncertainty added, the rational official will need to consider ex ante both the expected policy success and the expected illegality, but the calculation will still be based on the basic premise that if the policy turns out ex post to be successful, and even if the legality turns out ex post to be a determination of illegality, the illegality will still not matter or will matter very little. But if the policy turns out to be unsuccessful, and if the policy turns out to be perceived as illegal, then illegality will increase the political penalty. Some more complex calculation, but the basic issue is still the same. We could add additional complications to this. There are additional complications if we put in the highly contested issue of the authority of judicial determinations of what the Constitution means. That is, I used my example about two witnesses for treason is an example that comes directly from the text of the Constitution. If we add to all of this the question of disobeying the Constitution as interpreted by the Supreme Court, then we get into very current and hotly contested debates among judicial supremacists, so-called departmentalists, that is, each branch shall determine constitutionality for its own purpose, and popular constitutionalists. We could add a few other complications to all of this. including the elusive line between law and policy. Sometimes things that may have started out as law become policy, or become internalized as non-legal factors. So let me give a recent example of this that comes from freedom of speech, which may have become a political value, even though it may have started as a second-order legal constraint. So consider the example of this recent event in which a Kansas high school student sent a snarky Twitter message, which was quite abusively critical of Governor Brownback of Kansas, saying that he, quote, blows, end quote, and that he, quote, sucks a lot, end quote. According to news accounts, members of the governor's staff discovered the message and expressed strong anger to the high school principal, who then in turn demanded that the student retract the message, which she refused to do. A day later, the principal retracted the demand, and the governor apologized for his staff's action, acknowledging that the staff had overreacted. But although the official backpedaling explicitly cited freedom of speech and the First Amendment, the question remains whether the officials were acknowledging the force of a legal rule just because of its legal status, or were relying instead on the fact that freedom of speech itself now has a degree of first-order policy and political resonance that it sometimes would be on a par with the political resonance of civility. If that is the case, then we might want to hesitate before identifying this as an example of legal constraint rather than an example of the existence within policy and political life of second-order values that at times exclude first-order policy and political preferences. Federalism may be another example, and I'm sure I could come up with some more. This paper has had a twofold purpose. First, to ask in a somewhat jurisprudentially informed way whether the law is in actuality as much of a constraint on official action as the ubiquitous self-congratulatory rule of law rhetoric often assumes. Once we recognize that obeying the law is more than just taking actions for law-independent reasons that happen not to violate the law, we are in a better position to ask just how much official obedience to law as law there really is. There is some, to be sure, and there may even be a great deal. But when sanctions are removed from the picture and the obligation to obey the law stands bare for all to see, it may be the case that, as an empirical matter, such an obligation is less a part of American public and official life than is often assumed. The law may be a rhetorical add-on for officials who select the course of action for law-independent policy and political reasons. But it may well be that the law as law serves far more to justify decisions made on other grounds than it does in reality to motivate the decisions of officials who have no reason to fear formal legal sanctions for violating the law. If it is true that sanction-independent obedience is not as common as many people suppose and as many officials advertise, then it may turn out that sanctions are and should be a bigger part of the picture than much of the jurisprudential literature of the last half-century has tended to imagine. Ever since Hart's 1961 attack on Austin's sanction and coercion-based account of legal obligation, practitioners of the arcane art of analytic jurisprudence have put the sanction-independent internalization of law as law at the center of explaining the nature and phenomenon of law. But if such internalization is rare, remember that Hart talked about the puzzled man and made an implicit claim about the relatively widespread existence of such puzzled men, as he put it, and the importance of a theory fitting the facts. But if such internalization is rare, both for officials and for the citizenry, it may turn out that coercion figures more prominently in a sound explanation of the phenomenon of law than it does in the writings of the modern jurisprudential tradition. And as public law becomes an increasingly important part of law in general, the necessity of legal sanctions in order to secure official compliance with the norms of public law may be a window through which we can examine the role of coercion, sanctions, and force in understanding how modern legal systems operate and, quite simply, what they are. Thank you.